whilst this consolidation is a culmination of 14 years' work, it is expected that within the next 2 years we will be issuing another Companies Act, in the sense that company law is constantly evolving, it's constantly changing, and it is continuously particularly influenced by the European Union. So particularly just with regards Part 6 of the Act, which currently deals with accounts, and this is very important. If you do have a company, you must file accounts. There is no getting away from it. Failing to file accounts is an offence, and I'll talk about all these kinds of things. But just to say, there's going to be another accounting bill introduced in the next 2 weeks, which has to be in place by the end of the summer. So whilst it will not actually be complementing what's in Part 6 here, you will see that this, within the end of this summer in 2015, we're already going to have another piece of legislation in place. And indeed, in 2016, we're going to be bringing in an audit directive that we have to bring in. So yet again, we're going to see further involvement there. So this is not a static area, but unfortunately for all of you, this is not the most riveting area of law either, and I'm very mindful of that as a person who deals with this. It's a technical piece of legislation, and it is about companies. This is not about people. This is about the legal entity that is a company. Okay, so my name is Tara Coogan, Company Law Unit, Department of Jobs, Enterprise and Innovation, and Michael already referred to the Action Plan for Jobs. This piece of legislation also falls within that big picture approach that the department has taken in trying to ensure that our Irish systems and regulation help kind of modernise businesses. We're reducing red tape where it's appropriate, but we are also emphasising the compliance. Company law is not about getting away with everything and anything and not having any personal liability attached with it. If you run a company, you have certain privileges that come from limited liability, but with those rights also come certain responsibilities. And this Act also emphasises those and hopefully clarifies, because there is an awful lot of confusion out there. People don't always know what really is expected of them. And as I said, we're not all going to be experts on everything and anything. It is a big piece of legislation. But what my main aim really here would be is to give you a understanding of the Act, but also not to be afraid to approach it. Because there is a brilliance, it took me a while to get used to it. I've been hanging out with this piece now for about 2 years. I am quite familiar with it. But there is a certain simplicity in how you consult the Companies Act that certainly would not be there if you're going backwards, like last week. Because one of the things we had in company law in Ireland was we had 17 different instruments, legal instruments, since 1963. And since 1963, we've been introducing company law. That's been amending that 63 Act. Then you have the all these various pieces in between. And sometimes you'd be looking at sections now, and it's a 1963 Act that's been amended by a 1990 Act, and then a 1999 Act, and then a 2005 Act, and then possibly a 2009 Act. And if you're not legally savvy, you wouldn't necessarily be even able to follow all these amendments and see where the current situation actually is. This Companies Act now is setting it as it is. So you don't have to go and read loads of different pieces of instruments. And that in itself has a simplicity and a brilliance to it. So the design and structure of the Act is something I will be talking to you about, because I think it will make it easier for you to use it. There are 1,449 sections in this piece of legislation. When I came on board, when it had been initiated as a bill, we had 1,424. The Minister was slightly annoyed that we didn't get it to 1,450, just to keep it simple, but we did add a number of missing sections, and this is part of the consolidation. We realised that we'd missed certain areas, or we introduced certain areas where we needed clarification. So the bill has grown, the Act has grown a little bit from the bill. But the structure is really the most important thing that I hope you will get out of it. I'll be giving you some idea of the key features and the benefits of the Act. And I'll also be talking to you what's known now as the private company limited by shares. And I'm surmising that most of you who are considering or who have companies have private companies limited by shares. That may not be your option, and I'm not saying that this is the best company type at all. I'm just merely going to talk about this company type because it's the most common company type in Ireland. We have over 90% of Irish companies are private companies limited by shares. What the Act now does is introduces a new pared down version of that. It's a much simpler version, and the idea is that it'd be much easier to set up. It'd be much easier to draft we won't be using memorandum of articles and association anymore. We'll be talking about a constitution. All these kinds of things are much more straightforward under the current regime. Now, it says part by part review. There's 25 parts in this particular act. I have 1 hour, so I will be skipping over some of them. And I apologise if there is anybody specific here who's interested in mergers or something like that. Certainly I can give you information afterwards. And I will also be giving you information on where you can get more detailed information about everything, because in the next few weeks we will be publishing a lot of helpful materials, hopefully. And commencement, conversion and transition. Commencement, it is the law now. Since Monday, the 1st of June, the Companies Act is the act that governs company law in Ireland. Conversion is effectively something, if you have an existing company type, there are certain steps that you may have to take. Emphasis on the word may. Some companies will not need to do anything, but some companies will have to do something. And I'll just be indicating to you what the transition period is. So we started 1st of June 2015. There's an 18-month transition period. By the end of November 2016, old company law, effectively will be scaled out in the kind of company formation structures. So I've already mentioned that this piece consolidates 17 acts and 15 SIs. SIs are statutory instruments. We're talking about secondary legislation. These are pieces that are put in place to assist primary legislation. So they're kind of rules that the minister usually signs, setting out how something operates. So some of these, the 15 of them, have now been consolidated into primary legislation. And on Tuesday, I think we issued something like 16 new SIs to support the current Act. And this project has been ongoing for 15 years, so it's not something we threw together overnight. There's been a lot of talk, a lot of involvement. The Company Law Review Group is an expert body of individuals involving legal professionals, accountants, various stock exchange, bond markets, all kinds of people, trade unions, etc., who have sat for a very, very long period of time looking at best practice, not only in Ireland, but across Europe, and looking at how we can rationalise company law. And it is very much on their recommendations on which the reforms on this Act operate. And so consolidation and reform is effectively the message of the day. So unfortunately, my actual copy, if any of you recall what a phone book looks like, if you go and buy the Companies Act currently from the Government Publications Office, you'll get 2 phone books. And one of them is Volume 1 and the other one is Volume 2. If you are a private company limited by shares, the simplified, modern, the new company, if that's the way you want to go, you only need to worry about Volume 1. If you are any other company type, then you need to also rely on Volume 2. And these, just to give you an idea, the 1,000 suggestions received is when the bill was published, and this is something that you should know about all Irish legislative processes, is when a bill is published, it becomes part of the public domain. Anybody can make submissions and recommendations with regards how they regard the law or how they regard the interpretation. We received over 1,000. We passed over 750 amendments during the process. So when this bill went through the houses of the Dáil and the Seanad, we made recommendations on behalf of the Minister suggesting that these were improvements that we thought were relevant to the Act, and those were passed. Now, the figures are this looks like we carried almost everything that was recommended to us. That is not true. Those 750 amendments would have included typos, cross-referencing mistakes and things like that. Really, substantially, we probably addressed about 200 specific issues in the Act. And these really aren't changing the law. There's no policy change in any of those amendments. What was really introduced from the bill stage. But what we were doing is trying to clarify situations where people were coming back to us saying we don't understand what this section is trying to say, or it's saying it badly. And we do know that 320,000 directors in Ireland will be affected by this change. And if any of you are current directors of companies, you would have received a letter from the CRO, that's the Companies Registration Office, informing you of certain issues very recently. I got one about 2 months ago, I think. So communication is ongoing, and hopefully people are getting that information, and just as I said, I will tell you where you can find more of it. So Volume 1, that's the new private company limited by share. Volume 2 contains all the other company types, as well as market abuse and other types of matters that weren't appropriate for Volume 1. Now, the other company types, and yet again, I'm not going to be testing you at the end of the day, and there's going to be a lot of confusion with regards to this because these are new. Some of these are very new. So we have what's known as a limited, and that is not the limited as of old. This is now the new limited company. So that is a company that will not have an objects clause anymore. It will be able to act exactly as it wishes without having to rely on its constitution. It will be assumed to have the capacity to do whatever it wishes. Designated activity company is then what we would understand the current limited company to be. So a designated activity company is a company that will have an objects clause. And the reason most designated activity companies will have an objects clause is because they might be insurance undertakings, they could be financial institutions. The rules governing those specific companies, additional rules, would insist that they have such. Or you have owners who want to be very specific, shareholders who want to be very specific to what the company does and does not want to give the company the power to enter into any type of transactions. Equally, we would expect some charities might go this route. We will have public limited companies, which are PLCs. They are currently in place, and the law around PLCs is very much effectively the same. We will have guarantee companies, which are companies limited by guarantee, and these tend to be charities quite often. Not all CLGs are charities, but many charities are CLGs, as well as multi-unit development. So if you live in an apartment block, you will know, if you own the apartment, that there will be a management company. They're quite often CLGs, and this refers to public CLGs. So if you are a private company limited by guarantee current or under the last week's rules, you then would be a DAC limited by guarantee. So that's just to confuse people. We also provide for unlimited companies, which will be known as UCs or ULs, UCs. And we provide for 3 different types of unlimited company. Now, I'm not going to get into these very much because I can't see unlimited being very relevant to this particular room, but an unlimited company is one where the shareholders do not enjoy limited liability. They are personally liable for the transactions of the company. And you might say, well, why would you go for a company type if you don't want the limited liability? And the reason is unlimited companies don't need to do filing in the same way as limited companies do. So for competition reasons, people rely on the unlimited companies. We expect this to come to a bit of an end because the accounting bill that I mentioned at the very onset is actually going to be changing the rules around unlimited companies, and there will be much greater filing requirements coming down the line. We provide for external companies, and an external company, simply put, is a company that is not incorporated in Ireland but which operates in Ireland. Now, we have done away with the office idea, which the old company law would have provided for, which meant that you still were able, as a company that operated in Ireland but had no filing or any kind of presence really in Ireland, was able to get a CRO number. That is no longer available. If you want to have a company identifier in Ireland, you must be registered with the CRO, and therefore you must be a branch. And that means then that we will have some idea of what it is that you're doing. There will be certain filing requirements. We provide for unregistered companies and joint stock companies. These are companies that aren't companies. They are companies that were formed before the Companies Acts regime. The statutory instruments were invented, so these are companies that are formed under charter. Bank of Ireland is most commonly known, unregistered company. And then we provide for investment companies, which are public limited companies, but they have a very specific function in that they're investment vehicles rather than real company structures. The big change is that from Monday last, you can form any type of company, any of these types of company, with one member. And the simplified limited that I've mentioned can also only have one director. However, you must have a separate company secretary, whereas any other company type must have at least 2 directors. but one of those directors can be a company secretary, and I'll be talking a little bit about why that is. Okay. So when I said to you about the structure of the Act, now, as we all know, companies are perpetual. They do not die. They don't have the same lifespan quite like we as human beings do. So companies can go on over generations. However, I would still say that the Act does introduce a kind of a life cycle of a company. If you are about to set up a company, you will focus on the beginning of the Act. So you'll be looking at incorporation and registration, part 2. You'll be looking at that, and that will be setting out for you, if you're a limited company, exactly what it is that you need to do, what your constitution needs to look like, what needs to be in it, etc. In addition, the Act provides now in Schedule 1 a simple draft constitution for anybody. If you are happy enough to go with the default constitution, and I'm not saying you should do so, I'm saying if you wish to do so, having consulted the provisions of the Act and knowing what you're agreeing to, that is all you need to do really, is to fill in the default constitution, have the names of the shareholders inserted, and there you have it. You have the founding documents of your company. When you pass then incorporation, you then look at how does a company go about its everyday business. So how do you administer a company? What's good corporate governance? What do directors' duties? What is our filing requirements? They're all provided for in the middle of the Act. Then the Act moves into the kind of more challenging times that companies may face, the ailing years, if you like. So we talk about receiverships, examinerships. These are areas where the company might have some financial difficulty. It might be looking for court protection, or a creditor has moved in to acquire their monies from the company. And then it provides for liquidations, which is the natural, the winding up of a company. There's also provisions naturally for strike-off. And then the latter parts of the Volume 1 really only deal with issues such as investigations and offences. So for the first time in company law, what we're doing is we've created a very straightforward category of offences. So wherever you're going through the Act and it says you must do X, and if you fail to do X, it's a Category 3 offence, you will then be able to know what does that actually mean. And a Category 3 offence means effectively you're looking at a summary offence, so it will be a district court type of an offence. You'll be looking at a fine of up to 5,000 and up to 6 months in jail, right? Whereas when you're looking at Category 1 or 2 types of offences, you then also will know that these are offences where if the DPP takes the view, you could go on indictment and you could be looking up to 5 to 10 years in prison. So they're very clearly set out. There's no confusion around what kind of an offence comes with what type, and also it's very instructive for the courts. All right, I'll actually get Latifat to send you these slides, as there is an awful lot here to take in. I appreciate that. So I suppose one of the kind of general things that may, for those of you who are very familiar with the old company laws, you might kind of say, oh, this looks a bit different. But really, a lot of the modernisation is we've just started using terminology that is more modern, up to date, and more in line with the European Union. So you'll see that definitions may have changed, but really, it's not like the intent or the matters behind them have. So for example, company director constitution. We do not use memorandum of articles in association, except where they're appropriate. But in the Volume 1, you will only see the word constitution. The constitution is now what's going to be the governing document of a company. And that's a C with a small c. The big C constitution is the one that governs Ireland. Okay, so we're not overtaking that. So I've already mentioned this. If you are taking that very simple new company type, you will no longer have objects clause. And this just makes life very straightforward for a company, because a lot of people spend a lot of time trying to invent objects clauses that cover every eventuality. Because if you don't have objects clauses that cover every eventuality, you have to amend your articles in association every time. That's costly, time consuming, etc. So the idea here is that, if you as a company and the owners of the company decide that this is the way you want, you're happy enough to set up your company, there's a certain straightforwardness to it. The doctrine of ultra vires has been disapplied, and it has been disapplied throughout the Act. And what this is, without going into it too much, is just this idea that what was taking up a lot of court time is third parties would enter into an agreement with a company. something goes wrong, then the company says, well, actually, we didn't have the power to enter into this arrangement or contract or whatever with you. It's outside our objects clause. Therefore, that contract is void. This kind of arguing is now done away with. We've taken away the seal. Now, seals are still required for public limited companies and the more complex company types, but the simple limited company, no longer. And as I've said to you, single document constitution. And the thing about it is you can go for what are known as the default rules, but where the Act provides, it will use a phrase saying, save where the Constitution provides. Otherwise, that means that you as a company can elect to introduce your own rules in those particular provisions. But you have to do that proactively, obviously. I've mentioned the 18 months. So on Tuesday, as Monday was a bank holiday, if you were the old limited, if you have an existing company, private limited company, you are now a DAC currently. You would be understood in law to be a DAC, as in you still have your objects clause. If you do nothing for the next 18 months, as in you don't proactively want to become another type of company, at the end of the 18 months you will be deemed to be the modern limited. And effectively your current articles in association will be deemed to be your constitution, but the objects clause will be taken away. But effectively you don't have to do anything. If you are a current limited and you need to remain a DAC, you will have to proactively approach the CRO, fill in the relevant forms, and you must do so within a 15-month period. If you fail to do that within the 15-month period, you will be deemed to be a limited, and for some companies that will be a very serious problem. So, but as I said, I don't know if anybody in this room is within that category, but there are certain time limits, but they really are more applicable for much more, I think, kind of insurance undertakings and financial companies and so on and so forth. Statutory bodies, for example, or companies that are set up under statute will fall into that type of category. Now, also the limited company type, just to say, as I said, you can own your own company with the one member now. That's fine. Nobody's expecting you to have the minimum 2 or 3. So, you don't have to have the family child or the wife or anybody else on the board if you don't want to, or the husband. But equally, you can have up to 149. So it can actually be quite a large company if that's what you wish. And these are just effectively just provisions that, should you have a number of members who don't want to become deemed limited or they want to become a DAC, there's obviously powers in the Act for members to object. So it's not, this is not deemed in law that this is what has to happen. Members still can proactively make decisions around these issues. Now, one of the kind of benefits of the new company type is that we are providing companies with the power to do a lot of their internal management issues, if you like, by written procedure. So they don't have to call AGMs anymore. You don't physically have to be in the same space. But yet again, it's a matter for the company, but the power is there. If companies are happy enough to conduct their business by using ordinary resolutions or majority written resolutions, that's fine by us. So this is another kind of an area where we're anticipating that companies will be able to operate a bit more effectively without having to give massive times of notice and trying to organise a venue and so on and so forth. Oh yeah, these are just, sorry, I'm going to move on, because those were just, yet again, additional provisions to the transition period. This is the sample constitution as it is in the Act. So this is what your limited company now would be required minimum to submit. Now obviously these bits would have to be changed. So it's not that you just take it down, obviously you need to put in your own company name, etc., your share capital. But that's really it. It's very straightforward. I suppose I don't want to go into share capital and these types of things because this is quite a technical matter, and I don't know how many of you issue shares or deal with shares specifically. But just one thing is, if you opt for the simple limited company, you may not list any securities under the Companies Act. So if you want to list securities, you need to be another company type effectively. And this summary approval procedure is one of the greatest innovations in the Act, and it applies in a number of areas. And effectively, what its purpose is to reduce court involvement in all kind of transactions that company might want to internally carry. So summary approval procedures, yet again, they are protected. So it's not like there's not provisions that if members feel that their rights have been trampled on or whatever by the procedure, they obviously can go to the court. But effectively, where things are working harmoniously, the company wants to reduce its capital, the company wants to wind up, the company wants to do number, merge, whatever. When there is appropriate consent among shareholders, this can be done using these summary approval procedures. So that's a new innovation of the Act, and unfortunately it's going to be known as a SAP. And we expect spring SAPs to be, these are going to be procedures that will be used around the times when people submit their financial accounts, because when you're using SAP procedures, you do still have to ensure that your shareholders are clear on what your financial situations are and so on and so forth. But these are not shortcuts, but they are trying to remove the court involvement in everything and anything. Corporate governance then, which is an important part if you are thinking of setting up a company. And as I said to you, the simple company now can have a single director. And this is really to reflect the reality. We know that most of the companies, the 90% of Irish companies, are really owned by a person and run by a person. But we had these artificial requirements. So, for example, when we've looked at the CRO register, we've discovered that there are 6-year-old directors in Ireland. It is no longer possible to be under 18 and be a director of a company, because it's ludicrous. I mean, if you are a director of a company, you must be able to enter into contracts and agreements. Contract law does not recognise 6-year-olds. So there has been this kind of anomaly there, and it has been this kind of tokenistic approach that has existed in company law, and we've tried to do away with unnecessary areas. But what we are saying is that if you are the director, we'll move to part 5, you have very clear responsibilities under company law. And it's not okay to go to the court and say, oh, Judge, I didn't know this. You are expected to know your duties, and you're expected to act in a certain way towards the company. But whilst we say a single director is acceptable, we are also saying that if you are that single director, you must have a separate company secretary. And that is because we're saying a company secretary is actually a very important role. And a company secretary is the administrator of the company, make sure that the company adheres to its own rules, but also has a duty to ensure the company is adhering to the rules of Companies Acts. Directors, obviously, all must adhere to the company law, so that's kind of a straightforward issue. So we've codified the rules of internal management in part 4. And any of you who have dealt with the 1963 Act, that's the first Company Act, will know the Table A. Effectively, majority, and I'd say bar 2, have been incorporated as default positions in the Act. But that's not me saying you shouldn't look at them and not identify what are relevant to you or your company and modify the ones that you need to modify. You are entitled to do that. And as I've said to you, save to the extent that the company's constitution provides otherwise. That means you, as the company, have the power to decide, provided that obviously your company shareholders agree. But, so you can change some of the terms that are in the Act. I've said about the AGMs, they're optional for limiteds. And this elective opt-out, yet again, these are, you do have to consult with your members. You can't just kind of decide to do everything on paper, certain things like that. A majority of written resolutions can be passed as ordinary or special resolutions, so that's a new thing, and will take effect 7 and 21 days after the last member has signed. And yet again, there's an issue here so that you can make sure that you don't have to have everybody in the same room, so you can send resolutions so that the time is understood when the last person has had sight and agreed to whatever it is you're agreeing to. So this is the SAP that I've already referred to, and you will see the types of situations where it will be used. Now, duties of directors, part 5. This is an innovation of the Act. Nothing here is new. These are rules that have been in common law for at least 150 years. But what we have done is we've codified them, we've put them in one place. If somebody says, well, what does a company directors or duties, will say, well, look at section 2.2, whatever it is, and 228, and they're set out there. The list is not exhaustive. It is not a prescriptive list. It is merely saying that a company director must act honestly and responsibly and in the best interest of the company, etc., etc. These will be matters that a court will decide. If, you'll have to look at the bigger picture to see whether you have adhered to those rules or not. That is not what this is specifically trying to do. It is just saying to people, look, we've heard so many people say we don't know what duties directors are supposed to have. They're here now. They're in black and white. They're very straightforward. And as I said, you don't have to go and read 150 years of case law to identify them all. Also, what is very important in this particular part is that if a company director now takes a loan or gives a loan to the company, which often directors do, they must put it in writing. It is not okay anymore when a company's in a liquidation or a receivership type of situation to say, oh, by the way, that 50,000 that's sitting in the account, actually I lent it to the company. That is not, if the money is there and you do not have it in writing that you have lent your own personal money to the company. And I appreciate sometimes it can be very confusing because you are the company and the company is you, but you must keep your private finances separate from the company. If you do, for whatever reason, lend money to the company, make sure it is in writing because you will have no claim for it if it doesn't. The law will assume that it was a gift, and that is specifically set out. Yeah.
What way in writing? Because you can write later on, after 2 years, just...
No, you keep records, obviously, as you keep accounts, so if you're, surely you record every monthly transaction that you do. So you would be recording it then and there, obviously, whenever you give the money, and it would have to be indicating in your books and ledgers. And when you look at the provisions, looking at your books and ledgers, there are rules setting out that you can modify those posts. If you have to do so in a manner that indicates that they're not being interfered with. So it's not something, because until now, people can go and argue, well, actually, I lent some money, and it's just that we haven't had any evidence. What we're now saying is, if you are giving the company money for whatever reason, make sure you evidence that transaction. Because startup companies always, people, obviously, they put their own money into it, but you need to protect that. But we have unfortunately seen it being used the other way around as well. Part 6 is not something I'm going to talk to you about because it is about filing and it's about accounts and it is about the absolute requirements that every company has. We're coming up to half an hour to file every year with the CRO. If you fail to file, it's an offence in itself. It's a Category 3 offence, but also your company will be struck off from the register. And that means that you will no longer have that kind of active status. So the thing about the Part 6 is it effectively uses new language, but that new language is, so financial statement is used now instead of accounts. Nothing new there. Accounting records, books of accounts. So we're just really updating the terminology. And I suppose one of the kind of interesting thing is that we do provide now, so if you submit your accounts to the CRO and you realise within a 28-day period, oops, mistake has occurred, you can rectify them, you resubmit your accounts. Now they will go up side by side, but you are able to fix mistaken accounts for a period of time. So that is a new voluntary revision that we have there. And just with regards financial accounts, audit requirements, the thresholds for audit requirements, we are providing audit exemptions to companies, all types of companies now, except PLCs, etc. But it actually is much easier now to qualify for an audit exemption. Small companies usually would not have to worry about this issue. We're talking about companies that have a balance sheet of 8.8 or 4.4, 8.8 turnover, 4.4 balance sheet, or 50 staff. We're talking about quite a substantial company before you have to start auditing your accounts. But those thresholds have been upped in this particular act. I'm going to stop now because my half an hour is up. Thank you.